or the Pepsi Center at a concert. And a bunch of people around me were smoking marijuana, but I wasn't using it, and that's why I tested positive. You'll get that argument quite a bit. The response to that argument is, number one, there actually have been some studies in terms of secondhand levels of marijuana smoke that a person would have to ingest over a period of time in order to test positive for marijuana. And basically, you'd have to be in a tiny closet with another person for around 8 hours. Now, if you were in a pub tent or something up in the mountains and your partner was smoking marijuana all night, that would probably be enough. So what do you do in that situation when you get posed with that sort of a situation? You could do one of two things. You could put them on a last chance agreement and say, if you test positive again, you're gone. Or you can just say, you're going to be subject to random drug testing in the next 6 to 12 months. And if you test positive, you're gone. So you could put them on a last chance, or you could just say, okay, we'll give you another chance. But if you test positive again, you're gone. Now, if you give them that other chance and you don't do a last chance agreement, you at least need to document in their file that you have counseled them and that you essentially put them on a final warning. Okay? And that's how you address those situations. Because that does come up, and again, it may be a valuable employee that you don't want to terminate, and so you need to be careful. And getting back to the issue in terms of the employee being stigmatized in terms of their drug use, as you are probably all aware, it's very important that you keep drug testing results confidential, and that you limit the access to a specific need-to-know basis. And frankly, if somebody does present a medical marijuana card to you, remind them of your policy, but don't ask them why they're using medical marijuana, because that will open up a can of worms. And if they disclose that they have HIV or some other communicable disease, and you turn around and fire them, they're going to claim you didn't fire them because they violated your zero-tolerance drug policy. They're going to claim that you fired them because they disclosed their HIV condition to you. And under HIPAA, this is going to be considered protected health information. And so you're going to have an added layer of duties to ensure that this information isn't improperly distributed to folks.
Is there a standard period of time between the first test and the second test to ensure there's not positive, second positive? Because we know, for example, as you said, up to 30 days. Well, we're seeing 45 days pretty regularly with the potency here in Colorado. And talking to a person who's running the treatment center back east said he's seen up to 70 days, where it's not just the guy was using a treatment, it was clear the THC level was on a decline that you would expect that this was a large overweight man. And he said 70 days later he was still testing positive.
What I would do is I would probably tick on the calendar 4 months. 4 months. Because at that stage, they're not going to have any argument. They're either actively using it or they're not. And so that's what I would do. In some situations, I've known that some employers have drug tested in 60 days or 90 days. But to be on the safe side, that's 4 months. Unless you believe that they're impaired or under the influence of work, and that's causing a potential safety problem for you. If that's the case, then you're going to have reasonable suspicion to drug test them right then and there. And if they test positive and they've signed a last chance agreement, fire them. And frankly, if they test positive based upon a reasonable suspicion isn't just a rumor that the person is using marijuana. That's your independent or your supervisor's independent observation that this person may be impaired or under the influence. Maybe they confided in a coworker that they were using it, and you can ask them, are you using marijuana? Are you currently under the influence? They admit to it, drug test them.
So I think what I'm picking up from this whole discussion is that if you've got 2 employees and your company's policy is to be lenient on marijuana, but not to be lenient on other drugs. So you've got somebody with a marijuana addiction who is not let go, and you have somebody with a cocaine or et cetera addiction, and they are let go, that person can bring a discrimination charge against the company.
Well, that would be an interesting case. They'd have to define what sort of protected class that they would fit in. Drug users are not a protected classification currently under federal or
But you
state
said that
law.
addicts are. So.
If they have disclosed to the employer that they have an addiction and they are entered into a drug treatment program, you can't terminate or discipline them for that disclosure. You can terminate or discipline them for their current use of the drugs or even of the alcohol.
Precisely. And I guess that's my point, that if you have two employees in exactly those same situations, and one is terminated because they're continuing to use cocaine, and the other one is not terminated even though they're continuing to use marijuana.
I think that's I mean, my question to you would be, why are you continuing to employ the person who is using marijuana? I think that's problematic. Because, and I think that's problematic not from a discrimination standpoint, I think that's problematic from a personal injury tort law perspective. Because you, as an employer, have a duty to third parties to make sure that you are adequately supervising your employees. And if you are keeping an employee, let's say that you terminate an employee who tests positive for cocaine, but you don't terminate the employee who tests positive for marijuana, okay? And that person who tested positive for marijuana is driving one of your company vehicles and runs over Susie in the crosswalk and maims Susie, for instance. Guess what? You're gonna get sued as the employer for negligent supervision. And when you get deposed, you're gonna have to explain why you kept this person employed, whereas you fired the cocaine user. You're on notice that this person tested positive for marijuana. What did you do as a reasonable employer to deal with that person? Did you insist that they go into a substance abuse treatment program? Did you do random drug testing of this individual? Did you put them on a last chance agreement? Because those are things that, frankly, a reasonable employer would do. If you don't do those things, you're gonna be liable. And most likely, your commercial general liability insurance isn't gonna cover you.
Can you comment on your thoughts about, we've talked about the ADA protection if they've disclosed having an addiction as a covered disability. Can you comment on your thoughts about somebody who hasn't disclosed it in that format? Perhaps they've said, yeah, I use something, but they haven't said, I have an addiction, it's a covered disability, I'm seeking treatment, and asked for accommodation. And how that can impact the possibility of them being seen as regarded as having a disability and therefore are covered under the ADA even though they haven't disclosed it.
Well, and again, in this situation, if the employee is saying, maybe at lunch, oh, well, I use marijuana to help treat my hepatitis, which can be a derivative of HIV. And the scuttlebutt gets around, but then they haven't necessarily come out and said that they have an addiction, but they want some sort of accommodation. You don't have to accommodate them under the ADA in that circumstance.
I'm actually thinking of it kind of a different line, more along the lines of, kind of what Rader was saying about, somebody being seen as a drug user and therefore sort of stigmatized. Say you then terminate them for a performance issue down the road, which I think you've said pretty clearly is a much more solid way to go. But if you do that, could they then come back later? And I mean, certainly anybody can allege anything they want, but would there be a potentially risky situation where they could allege, well, you're saying you terminated me for performance, but in reality, you regarded me as being an addict based on this information that you knew, and you therefore treated me differently than you treated other employees. And that's where I'm thinking, regarding someone as having a disability, regardless of whether they've actually said they have it, and regardless of whether they actually have it. Because I've seen that where, you know, employees are seen as having, say, a mental illness, when in fact, they're just weird.
Well, okay, so in that situation, the employee's gonna have to make a causal link between their purported or how the employer is regarding them as being some sort of drug addict or drug abuser, and that somehow that is linked to their disability. So they're gonna have to show that they have some sort of disability or they've been regarded as disabled. And the fact of the matter is they don't have protections under the ADA unless they disclose to the employer that they actually have an addiction and they want to seek treatment. Otherwise, they don't have a disability protection under the Americans with Disabilities Act. And so they can't argue that, well, you regarded me as a drug user and based upon my disability and that's why you terminated me, and it wasn't because of course they can try and sue you on that point. I don't think that that's going to be successful because we're not going to be able to establish the link.
Could you clarify then the regarded as having a disability thing? Because I think maybe I was misunderstanding how that worked.
Yeah, so under the Americans with Disabilities Act, if you regard a person as being, you as an employer, regard an individual as being disabled, then you are going to have to treat them as disabled, and that means you're going to have to engage in an interactive process with them and determine if there are accommodations that will allow them to perform the essential functions of their position that are reasonable and don't pose an undue hardship to you, okay? Now, and a lot of the times that can be used to establish liability. What I'm advising my clients nowadays, because of the amendments to the ADA that we talked about at the very beginning of the presentation, I think it's better off that the employee treats a person who comes forward with some sort of medical condition, treat it as a disability under the ADA. And you can even couch it as, although at this stage we're not necessarily conceding that this is a disability, you know, in an abundance of caution, we are going to engage in an interactive process with you and go down that route. I think that's much safer than trying to argue that it's not a disability or it is a disability. I think that courts are going to lean towards, if they can establish that it's a disability, they're going to do that. However, what's important to remember is that drug use, alcohol use, is not a protected disability unless they avail themselves of the safe harbor provision, they say they have an addiction, and they want to get treatment. And all that does, folks, is that prevents you as an employer from terminating them, from making that disclosure and going into the treatment program. That doesn't prevent you from terminating them if they test positive for alcohol or marijuana or some other narcotic.
But that has to come first. But that has to come first, so that if, you know, somebody is about to be terminated, goes into treatment, gets terminated because they're testing positive, whatever, comes out of treatment and says, oh, I just discovered while in treatment that I was an addict. I didn't realize that before. And therefore you should not have terminated me because I am actually an addict, even though I didn't know it.
Well, I mean,
because that's going to happen all the time, that, you know, people aren't going to acknowledge that they're addicts until...
if they don't acknowledge that they're addicts, then they're not protected. It's that simple.
Well, and another thing too is we get a special classification of employees that are covered under DOT.
Right.
So the guy comes up drinking marijuana, and they refer to not only EAP, but they refer out to medicine, to substance abuse professional. And that SAP says, okay, this is what you have to do with regard to the employees. Okay, mandatory 6 to 12 drug tests that first year. But that is, they can follow a guy for 3 to 5 years.
Right?
So they got a whole time frame. Like 4 months, they should be good.
Yeah, I mean, and what's really important is to educate our employees in terms of what our policies and expectations are. Because you're going to have so many employees out there who believe that they can just use marijuana on the weekend, as long as they don't come to work stoned on Monday morning, that they'll be fine. And if you have a zero tolerance drug policy and you do random drug testing, you need to let your employees know that this may be coming down the road, and if you test positive, you're likely going to be terminated. And it just
If you have any notes about regulated professions, so dentists, pharmacists, etc., what would those be? What recommendations or considerations should they have?
So, professionals, doctors, dentists, lawyers, there are all sorts of state regulations concerning substance abuse. You don't automatically lose your license if you test positive for these things, but frankly, if you get into a situation where you have a physician or dentist who tests positive or has been arrested, well, let me rephrase that, has been arrested and or convicted, they're going to have to report to their respective state licensing bodies within a very short period of time that they've been charged with this offense, and then they're most likely going to have to enter into a lengthy treatment program that these boards are going to mandate. Otherwise, they're going to get suspended, and ultimately their licenses could be revoked. If you have those sorts of folks, you need to educate them in terms of, not only does it violate our policies, but you're going to have a separate reporting requirement to the state licensure boards. Most professionals sure already know that, but if they don't, that would be good to remind them. I'm going to jump ahead real quick because I know we're running overtime, and I want to jump to the Coates versus Dish Network case, because that's really pivotal. Because Coates is really going to set the framework for what employers can do, at least in the medical marijuana context, for the next decade, unless the state legislature does something else. Mr. Coates is a quadriplegic individual. He worked in the call center at Dish Network in Inglewood. So his responsibilities were to deal basically with customer complaints about Dish Network all day on the telephone. He didn't even operate the coffee machine or the coffee maker at Dish Network. He didn't drive a vehicle for Dish Network. And as I said before, he's a quadriplegic. Dish Network has a zero tolerance drug policy. And they actually do random drug testing. And they did random drug testing, and lo and behold, Mr. Coates tested positive for marijuana. He presented his medical marijuana card to the HR representative and said, I use medical marijuana because I'm stuck in this, and this is his words, I'm stuck in this damn wheelchair 12 to 14 hours a day. It gives me a lot of pain and discomfort, and I smoke marijuana because that's the only thing that gives me the relief. I used it 3 or 4 days ago when I was off duty in my home and I wasn't working. And you, Dish, should not be allowed to fire me. Now, what did Dish do? The HR manager said, sorry, Mr. Coates, we have a zero tolerance drug policy, you're fired. So what did Mr. Coates do in response? Like any good red-blooded American, he sued. And he sued in Arapahoe County District Court. And he sued under the Colorado Lawful Off-Duty Activity Statute, which makes it a discriminatory or unfair employment practice to terminate an employee who is engaged in lawful, and notice that I bolded lawful, off-duty, off-premises activities. Okay? His argument is, I was engaged in a lawful activity, lawful because I was using medical marijuana under Amendment 20 in the practice of my own home, and under Amendment 20, that's a lawful use of marijuana. He was off-duty, he wasn't at work, and he was off-premises. He wasn't at Dish Network. And under this statute, you can't terminate somebody for lawful off-duty, off-premises activity. Okay? The trial court dismissed his case. He appealed to the Colorado Court of Appeals. And the Colorado Court of Appeals held, back in April, or April of last year, I should say, that by definition, Mr. Coates' use of medical marijuana could not be lawful. Why? Because it's still illegal under federal law. it's still legal under federal law.